Hello, everyone, and thank you for attending today's webinar, Recent Updates in Illinois Law. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of the screen. We will try to answer these during the webcast, but if a fuller answer is needed or we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. This webinar is CLE accredited in California, Illinois, and Texas for 1 hour of general CLE credit, and in Missouri for 1.2 hours of general CLE credit. The webinar is also CLE accredited in New York for 1 hour of experience and transition credit. We award CLE based on attendance for the entire 60 minutes. Due to changes in jurisdictional requirements, you will notice that we are no longer using automated pop-up attendance checks. As required, we will display secret words in 2 multiple choice polls during the webinar. You will be required to select today's secret word from a multiple choice list. Please respond to these 2 polls to demonstrate your continued engagement and to earn your full CLE credit. We value your opinions and appreciate your participation in the course. And with that, I'd like to introduce myself and my colleague, Zoe Spector. My name is Susan Lawrence. I'm a partner in the Chicago office of Thompson Coburn in our Labor and Employment Department. And Zoe Spector is also in our Chicago office in our Labor and Employment Department. Our contact information is included on this slide. And if you have any follow-up questions after today's seminar, please do not hesitate to reach out to either of us. So today we're going to cover a variety of topics. Illinois has been quite busy over the last year or so in introducing new laws, amending existing laws, and providing additional guidance as well. The city of Chicago, not to be outdone by the state, has introduced some of its own new obligations for employers with employees within Chicago. And we wanted to touch upon all of these in sort of a mid-year overview to make sure that everyone was on the same page as to what's been implemented in 2022, either as of January 1 or in some instances over the last couple weeks. Among those will be changes to the Illinois Equal Pay Act that impose reporting obligations, the new restrictive covenants, obligations, and restrictions under the Illinois Freedom to Work Act, and new leave entitlements under what was previously known as the Illinois Child Bereavement Leave Act, but has been expanded, as you'll hear, to cover more family members. We will also review key updates to the City of Chicago ordinances, including the new sexual harassment prevention training requirements and other updates to Chicago's Human Rights Ordinance. And with that, I'd like to turn the presentation over to my colleague Zoe, who's going to start us off with amendments to the Illinois Equal Pay Act.
Thanks, Susan. Hi, everyone. So many of you have likely already heard the buzz over the past year and a half about the multiple amendments to the Illinois Equal Pay Act. Though initially the statute was a bit confusing to understand, such as who is considered an Illinois employer, whether this applies to remote workers, the total potential penalties for noncompliance, among other quite frequently asked questions, the Illinois Department of Labor finally issued some long-awaited guidance that does help us better understand an employer's obligation under these new requirements. I'll go ahead and delve into some of the big-ticket items that employers need to know, in addition to some answers to those frequently asked questions about the amended Illinois Equal Pay Act. So the updated law imposes new equal pay reporting and certification requirements. On a broad level, this means that the law creates new obligations for employers to biannually report pay data and certify compliance with requirements under the Illinois Equal Pay Act. The updated law and its new reporting and certification requirements apply to employers with 100 or more employees. The Illinois Department of Labor will be issuing application deadlines on a rolling basis to Illinois employers with 100 or more employees between March 24th, 2022 and March 23rd, 2024. But I'll speak more upon those logistics later in the presentation. As an initial overview, employers who are covered under the Illinois Equal Pay Act must submit an application to obtain an equal pay registration certificate. The law provides that this must occur every 2 years for purposes of getting recertified. So once you initially submit your registration application, you must do so every 2 years thereafter. But again, I'll get into more of those logistics later in our presentation. So one of the most important questions for employers here, of course, is whether this law even applies to them, especially considering the penalties for noncompliance, which I will talk about later. There is more to being a covered employer here, aside from having 100 or more employees. The employer also must be authorized to transact business in Illinois as of March 23rd, 2021, must be a private employer, otherwise known as not a unit of local government, not a public agency, etc. Only private employers are covered under this law. And the employer must file an EEO-1 report with the Equal Employment Opportunity Commission. A covered employer's total number of employees is the total number of people who worked in or were based out of Illinois for that employer on December 31st of the 12-month calendar year immediately prior to your submission of the EPRC application. So, for example, if you're required to submit an EPRC application in 2022, in other words, if the Illinois Department of Labor provides you a response deadline to submit your application within the year 2022, your wage data should be based on the total number of people you employed who worked in or were based out of Illinois on December 31st of 2021. Employees who are based in Illinois should be included in the total employee count, even if they work remotely outside of Illinois. A business with multiple locations must only include those employees who work for an Illinois location. To emphasize, your employee count should include those employees who may work remotely in another state outside of Illinois. The count includes all employees of a business based in Illinois, even if the employees are working remotely outside of Illinois. Again, a business with multiple locations should only include the employees whose base is in Illinois. So after you submit your first EPRC application on a date that will be assigned to you by the Illinois Department of Labor between March 23rd, 2022 and March 24th, 2024, you will be required to recertify every 2 years thereafter. This will entail the same application process, and the Department of Labor will be sure to provide you notice of your recertification date at least 180 days before your recertification will be due. So during the recertification process, if you receive a letter from the Illinois Department of Labor, but your total employee count has dropped below 100 on December 31st of the year immediately prior to your recertification year, you are obligated to notify the Department of Labor and certify in writing that you are exempt from the EPRC requirements. So if you're in this situation and you receive a notice from the Illinois Department of Labor to recertify your equal pay reporting and certification, you must still notify the Department of Labor in writing that you are exempt from the EPRC requirements of Section 11 of the Equal Pay Act. This certification must be on your company letterhead and signed by a senior executive of your company. Exemption certifications must be sent to the Illinois Department of Labor via email or U.S. mail. So now we are finally going to talk about the elephant in the room. How do employers who are covered under the law report and certify compliance with the Department of Labor? So to start, you will need to submit an application, and I will cover the components of the application in the next few slides. First, I just want to reiterate that the Illinois Department of Labor will assign covered employers an application due date between March 24th, 2022 and March 23rd, 2024. The Illinois Department of Labor will notify covered employers of their applicable deadline at least 120 days before the application will be due. In other words, these deadlines are currently being assigned as of today on a rolling basis. To confirm or inform the Illinois Department of Labor that you are a covered employer under this law, you can visit the Illinois Department of Labor's business registration page and submit your business's contact information. The Illinois Department of Labor will then put your business on the list to provide a deadline within the 2-year response timeframe to submit your application. Now we are finally going to talk about the components of the equal pay reporting and certification application. As you can see, there are 3 distinct components. 1, a $150 filing fee. 2, the employer's wage records, including a copy of your business's most recently filed EEO-1 report. And 3, an equal pay compliance statement. The wage record must include a list of all employees from the prior calendar year, separated by the protected categories as reported in the employer's most recent EEO-1 report. In addition, the record must include the county where each employee works, the date the employee started working for the business, and the total wages paid to each employee during the past calendar year, rounded to the nearest $100. Wages means any compensation paid to an employee. So when you report the data, you must include any compensation. This includes wages, salaries, earned commissions, earned bonuses, stocks, and ownership shares. However, wages does not include retirement, health, or other fringe benefits. A helpful tool to know what wages you need to report is looking to the box 5 on the W-2, which should have this information for purposes of EPRC data reporting. Finally, the compliance statement must be signed by a corporate officer, legal counsel, or authorized agent of the business, which includes a certification that the business is in compliance with the Equal Pay Act and other relevant laws, that the average compensation for its female and minority employees is not below the average compensation for its male and non-minority employees, and that the business does not restrict employees of one sex to certain job classifications. So when reporting wage records as part of the employee data, if you have employees who have held multiple positions within the company, you must report each position the employee held, including the start and end dates and corresponding title and rate of pay. In other words, for employees who have been promoted, you must list the employee's original hire date and then list the termination date as the date they were promoted. You would then create another row in the spreadsheet for that same employee with the hire date as the date they were promoted. For example, if your reporting year is 2021 and a particular employee was hired prior to 2021 but promoted to a new role in that year, you would list their original hire date and then list the termination date as the date they were promoted. You would then create another row for that same employee with the hire date as the date they were promoted for purposes of submitting your spreadsheet and the wage data reporting requirement within this application. The final part of the application is the Equal Pay Compliance Statement. It must be submitted in writing and must be signed by corporate officer, legal counsel, or authorized agent of the business, as I emphasized above. The Illinois Department of Labor has provided an Equal Pay Compliance Statement template, which can be downloaded on the Illinois Department of Labor's website. And I'll show you this template on the next slide. So as you can see, the mandatory compliance statement includes certification that the business is in compliance with the Equal Pay Act and other relevant laws, including Title VII, Illinois Equal Pay Act, the Illinois Human Rights Act, etc. In addition, you're certifying that the average compensation for female and minority employees is not consistently below the average compensation. It's determined by rule by the United States Department of Labor for its male and non-minority employees. Third, that the business does not restrict employees of one sex to certain job classifications and makes retention and promotion decisions without regard to sex. 4, that the business corrects wage and benefit disparities when identified. 5, how often the business evaluates benefits and wages. And 6, the approach the business takes in determining what level of wages and benefits to pay its employees. So again, to download this Equal Pay Compliance Statement template, you can go to the Illinois Department of Labor's website on Equal Pay Act reporting requirements. So one question you may be wondering is whether the Illinois Department of Labor is going to keep your data confidential after you submit your application. The answer is sort of. Section 11 of the updated law allows the Department of Labor to compile aggregate data and reports based on the wage data submitted that includes the job category and average hourly wage by county for each gender, race, and ethnicity category on the EPRC applications. These reports are not required to be kept confidential. However, they will not include any data that could be associated to any individual business or person. Any such individually identifiable business or information identifying a person is required to be kept confidential under Section 11 of the Equal Pay Act. However, there are 2 exceptions to this. The first exception is that a current employee of a business is subject to Section 11 may request anonymous data regarding their job classification or title and the pay for that classification. No individually identifiable information may be provided to an employee making such a request. Another exception is that the Illinois Department of Labor may share data and identifiable information with the Illinois Department of Human Rights pursuant to its enforcement of Article 2 of the Illinois Human Rights Act or Office of the Attorney General pursuant to its enforcement of Section 10-104 of the Illinois Human Rights Act. So basically, the law is saying one of the exceptions here is if another government agency in Illinois is going to use the data for investigative purposes. So as emphasized above, I just want to reiterate that after a covered employer submits the initial Equal Pay Registration Certificate application, it will be required to do so again after 2 years, and then every 2 years again thereafter. The Illinois Department of Labor will send you notice of your due date at least 180 calendar days before such recertification will be due. So in other words, just to emphasize that this is not a one and done requirement. You're going to have to do the same application process every 2 years. So another thing a lot of listeners here may be wondering are what are the penalties here? What are the penalties if the Department of Labor investigates the wage certifications, and what are the penalties for not complying with these new requirements, et cetera? So first, if the wage data submitted in an employer's EPRC application shows that the employer is paying unequal wages to men and women employees or to African American and non-African American employees, the Illinois Department of Labor may initiate its own investigation pursuant to its enforcement authority. So then you may be wondering what happens to a business who does not comply with the Equal Pay Registration Certificate requirements. So a private employer who has 100 or more employees in Illinois and is required to file the annual EEO-1 with the EEOC and who commits a violation of Section 11 of the Illinois Equal Pay Act shall be fined up to $10,000. However, before any fines can be imposed for a violation of the Equal Pay Act, the Illinois Department of Labor will provide notice to the employer who violates Section 11B of the Illinois Equal Pay Act and advise them that they have 30 calendar days to submit the application or recertification in the instance that the employer inadvertently failed to file the initial EPRC application or recertification. So basically, the Illinois Department of Labor here is saying, we'll give you this 30 calendar day grace period if you inadvertently fail to miss your deadline. So falsification or misrepresentation of information on an EPRC application is a violation of the Illinois Equal Pay Act, and the Department of Labor in that instance may seek to suspend or revoke an equal pay registration certificate or impose civil penalties up to $10,000. So just to summarize what we went over today, private employers with 100 employees or more who file an EEO-1 with the EEOC are required to obtain an equal pay registration certificate from the Illinois Department of Labor. Employees who are based in Illinois should be included in the employee count, even if they work remotely outside of Illinois. In addition, a business with multiple locations must only include those employees who work for an Illinois location. The State Department of Labor will assign covered employers an application due date between March 24th, 2022 and March 23rd, 2024 to receive an equal pay registration certificate and submit their application to do so. Again, that application consists of 1, $150 filing fee, 2, wage records and recently filed EEO-1 reports, and 3, an equal pay compliance statement. And to emphasize, penalty for noncompliance can go up to $10,000. Okay, so that is it on the Illinois Equal Pay Act reporting requirements. So now we're on to today's first secret word, which is grape. Please select the correct word below. I'll give you a few seconds to do so. Okay, so I'm going to pass the mic over to my colleague, Susan.
Thank you so much, Zoe. And just real quickly before we move on, and while not on topic for Illinois specifically, I think it's important to highlight that while Illinois is taking the approach of requiring certification on things like equal pay, other states are taking different approaches and are now requiring pay transparency on job applications and job postings. So to the extent people are feeling like, oh, one more thing to deal with in Illinois, should we even be here? I think it's important to note that this is a trend that is not going away and is just being approached from different angles across the country to ensure that genders and minorities are all being treated equally when it comes to things like pay. So with that in mind, I'd like to now move to the Illinois Freedom to Work Act. This is a new law that went into effect on January 1 of 2022, so we've been living with this for about 7 months now. Rest assured, you are not alone if you have not done anything to review your restrictive covenant agreements, but I would highly recommend that you do so now. That being said, if there is any good news to report today, it's that these requirements are not retroactive. So if you have agreements that have been signed by your employees prior to January 1, you do not need to go back and ask them to sign a new one, nor do you have to worry about enforceability to the extent you have not met these same thresholds that we're about to discuss for previously signed agreements. So this would be more of a situation for any new hires, arguably anyone that would be a current employee who is being elevated to a new position that we would like to bring them within some of our restrictive covenants, or just best practice going forward to review templates. There are a couple of key elements of this law, including the first one that we're going to touch upon, which is the salary threshold requirement. This is not a complete surprise to us that the House of Representatives and Senate included this requirement in the bill that went to Governor Pritzker, because we saw in the past some case law around some lower income employees who were being asked to sign restrictive covenants and some blowback in the form of litigation for lower income employees. And so this is really taking that concept and building upon it. The law that went into effect states that if an employee makes less than $75,000 a year in expected earnings, and I'll touch upon that term in a second, they cannot be asked to sign a non-compete, or said another way, in order for us to ask an employee to sign a non-compete, they have to have expected earnings of at least $75,000. Expected earnings is a broad term. It includes things like bonuses, commissions, profit sharing, things like that. So we generally have to have a good faith basis to establish that they will in fact earn at least $75,000. If we know based on historical data that, for example, a salesperson in a particular region never has enough sales to meet that $75,000 threshold, that would be something that we would have to take into consideration when assessing whether we could defend against our decision to ask that person to sign the agreement. As I'm sure you can imagine, given how new this law is, we do not have a lot of case law or any case law that has analyzed an employer's decision to ask an employee to sign an agreement. So we're really making judgment calls at this point in time when determining that $75,000 threshold. If you are concerned about that threshold, please reach out to us and we can talk through the way in which we could defend against a claim that we believed that the individual had an expected earnings in excess of $75,000. The threshold is lower for a non-solicit. That's for both customers and employees, which is not particularly surprising because we've seen repeatedly that courts are more willing to enforce non-solicitations than they are of non-competes, which explains then why the expected earning threshold is at $45,000 as opposed to $75,000. The thought being that a court is willing to understand why you wouldn't want one of your prior employees to steal a bunch of your customers or steal a bunch of your employees and or trade secrets, which we're not going to spend any time talking about. But those are sort of the three buckets that courts in Illinois are consistently willing to protect, whereas a non-compete is less attractive to Illinois courts because they don't want to impact the flow of an individual's ability to switch jobs so long as they're not doing it by stealing our customers, employees, or trade secrets. This salary threshold goes up every 5 years by $5,000 over the next 15 years, at which point we would assume that the legislature will get involved and determine whether or not the salary thresholds are going up or if some other number is going to be determined. I see that there's a question about the thresholds, whether they're based on calendar year or employee start/salary increase. That's a great question, and I believe that the answer is on a calendar year annual basis, namely then a tax year, as opposed to when they're starting. So if that means that we're looking at a pro rata number, that would suffice. But to the extent someone has a base salary for a calendar year of at least $75,000, even if that means that on a pro rata basis they're making less than that, I would argue that we could defend against our decision to ask them to sign the non-compete. It's important to note that if we do violate any of these provisions, if we fail to meet that salary threshold requirement, the entire agreement is voided. We're going to talk a little bit more about that in a moment, but I want to drive home the point that this really is a necessary piece of the new law. A couple other pieces to touch upon before we move on to the next slide. A covenant not to compete under this new law is void and illegal if it's entered into with an individual covered by a collective bargaining agreement under either the Illinois Public Labor Relations Act or the Illinois Education Labor Relations Act, as well as for individuals employed in construction. So suffice it to say, the construction lobby is alive and well, and they enabled some carve-outs for themselves and ensures that they cannot be found to be subject to a non-compete or non-solicitation agreement. Hopefully this next piece is no longer as relevant, but given the timing of the enactment of this law, the law includes language that says an employer is not able to enter into a non-compete or a non-solicitation agreement with an Illinois employee who is terminated, furloughed, or laid off as a result of business circumstances or government orders related to the COVID-19 pandemic unless certain conditions are satisfied. Again, hopefully we won't be dealing with that again, but notwithstanding, that is included. The other piece that's particularly noticeable in the new law is the fact that it now requires that a non-competition or non-solicitation agreement be supported by independent, adequate consideration. Anyone on this call who's dealt with Thompson Coburn over the last couple of years in drafting non-competes and non-solicits has probably heard us talk about a case that came out of the Illinois Appellate Court a couple of years ago that held for the first time that a non-compete failed for lack of consideration because the only consideration given to the employee in exchange for signing the agreement was the offer of employment. And what this case said is that if the employee were to quit or get fired within 2 years of signing their restrictive covenant agreement, the agreement would not be enforceable if the only thing they got was the offer of employment. Now, that case went up to the Supreme Court. The Illinois Supreme Court refused to hear it. There were other appellate courts that found differently, so it created confusion for many of us as to the enforceability of that restriction. Well, enter the Illinois Assembly, who determined to codify this concept in this new law. And essentially, it came out and said that the adequate consideration concept would mean that the employee worked for the employer for at least 2 years after the employee signed the agreement. So there we have that case that I just mentioned. Or the employer otherwise provided consideration adequate to support the agreement not to compete, such as a period of employment plus additional professional or financial benefits, or merely professional or financial benefits by themselves, for example, a signing bonus. As I already mentioned, we don't have any case law yet that is going to discuss what that means, what additional professional or financial benefits means. So to that end, I have routinely been recommending to my clients that we give them the signing bonus piece and not rely upon the professional benefits. I assume professional benefits means things like training, exposure to different industries, things that further their career, but I can't tell you definitively how much training that requires, how many seminars we need to send the person to. And to that end, I can't even tell you definitively what a reasonable signing bonus would be. There's no discussion as to what that amount would be. Arguably, it's more than a de minimis amount. It's potentially a good rule of thumb to say a signing bonus should be at least a week of the individual's salary. Again, in the spirit of could we defend against our interpretation of adequate consideration, some formula like that I think would get us a long way. But we're certainly going to be waiting and watching for these kind of cases to come out to be able to provide further guidance on what a reasonable signing bonus would be. But the long and the short of it is we have to do something, or we just need to cross our fingers that the individual that we would like to be able to enforce the non-compete or non-solicit against stays with us for at least 2 years. Because if they leave for any reason inside of those 2 years and we've not given them a reasonable signing bonus, we will be very hampered in our ability to enforce these restrictive covenants. A couple other aspects of this law. Employers are now required to provide Illinois employees 14 days to review the non-solicitation or non-competition agreement and advise them in writing at the same time to consult with an attorney before signing it. So what does this mean? If you have a practice of onboarding your new employees and asking them to sign their W-4 and asking them to review the handbook and sign the acknowledgement and asking them to sign a restrictive covenant agreement all on their first day of employment while sitting in your conference room, that practice will have to end. We have to give employees at least 14 days to review it and sign it. Now, if they choose to sign it right then and there, we can't stop them, nor are we obligated to stop them. But my recommendation thus far has been to include the restricted covenant agreement with the offer letter, especially if the offer letter is sent at least 2 weeks before their start date, and advise them that they have 14 days to review it and to either bring it with them on their first day of employment or forward it to the employer in advance thereof. Alternatively, we could give it to them on their first date of employment, but then we'd still have to give them 14 days, which means if they work for us, start doing tasks, start getting introduced to our employees and our customers, and then leave at any point in time in those 14 days before they signed anything, they will not be bound by anything. So we're definitely taking on some risk if we allow them to start working before they would otherwise be obligated to sign the agreement. The other piece is that's of actual benefit is that the law codifies the concept of judicial reformation. The term blue penciling might be more familiar. In the past, there was a disagreement amongst the courts and the judges as to whether or not a judge could make changes to a restrictive covenant agreement that they found to be overly broad or unreasonable. Some judges said, I will take my pencil and take it from a 2-year non-compete to a 1-year non-compete, or I don't like the 50-mile radius, but I'm willing to do a 25. Other judges said, shame on you. You guys chose to get overly broad. I'm throwing the whole thing out. This law now says that judges can reform the agreement and will make it that much easier to convince a judge to do that. I should note, though, that the law does continue to emphasize the public policy against courts wholly rewriting contracts. So I don't want anyone to go into it thinking they can be as sort of onerous as they want in the agreement, and don't worry, the judge will take care of us. That is certainly not the intention of that acknowledgement, but rather to hopefully clear up for any judges who are unclear as to where the legislature stands in this, that they are in fact allowed to engage in judicial reformation. I do want to sort of end where I began, that if we do violate any of these new requirements, whether it's a salary requirement, whether it's adequate consideration, the 14 days, and ability to consult with an attorney or any other piece, the agreement is void. So while there is the right to judicial reformation, there is also that opportunity for a judge to simply say, you violated some of the clearest of obligations, like the salary threshold, like the 14 days, and as a result, I'm voiding the whole thing. So please do not hesitate to reach out to either of us and flip your current template to us, and we will take a look and see if we think they're currently enforceable. Don't be surprised if the recommendation is that we have 3 different agreements. One for those making over $75,000 that has a non-compete and a non-solicit. A second one for people who are making between $45,000 and $75,000 that has just the non-solicit. And then a third one for anyone making less than $45,000 with neither the non-solicit or the non-compete, but with a robust confidentiality provision that would also be found in the other 2 that at least protects our trade secrets and proprietary information. So with that, we are moving to Zoe's next section, which will be on the amendments to the Child Bereavement Leave.
Thank you, Susan. I'll just briefly go through these changes to the bereavement leave. So previously, unpaid bereavement leave was only available following the death of a child. Governor Pritzker very recently signed a new amendment into law which expands an employee's eligibility to take bereavement leave. So now unpaid bereavement leave is available for the death of a covered family member. And quote-unquote covered family members, as you can see from the slide, includes an employee's child, spouse, sibling, mother-in-law, father-in-law, step-parent, all of the family members listed on the slide. So additionally, employees can use the 10 workdays of unpaid bereavement leave to not just grieve, attend the funeral, or make arrangements, as they could in the prior law, but also for absences due to a miscarriage, an unsuccessful round of IVF, a failed or contested adoption match, a failed surrogacy agreement, a stillbirth, etc. So those are a few of the changes to Illinois' stance on bereavement leave, and please reach out if you have any questions.
And Zoe, I'll just pick up a little bit more of that. It's important to note that this law only applies to employers with at least 50 employees, similar to those who would be subject to FMLA. It doesn't go into effect until January 1 of 2023, so we do have some time to take a look at your employee handbook or any other policies to see if we need to be amending this, because if you already had your child bereavement leave in your employee handbook, that law applied regardless of the size of employers. So it's possible that we would want to keep that existing child bereavement leave and, depending on your size of employees, not amend it to include this new act. But for those of you with at least 50 employees, we will now, as of January 1, 2023, need to be offering more time for more individuals. Just as a reminder, the child bereavement leave required us to provide 2 weeks or 10 working days. This is now for more individuals. Now, the leave is still unpaid, so while it's not necessarily going to be a further burden on the company from a financial perspective, it does allow more employees time off, which is a change from the prior child bereavement leave and expanded to the family bereavement leave. The other piece to note is that the leave itself must be completed within 60 days after the date on which the employee receives notice of the death of the covered family member or the date on which one of the events listed above occurs. The final piece is that if an individual employee experiences 2 different events, triggering events, they can take up to 6 weeks of unpaid leave in a year. So it's not a one and done situation. The employee may, unfortunately, have a life circumstance where they may have 2 of these triggering events. So be aware that you would then have an obligation to offer up to 6 weeks of the leave. And again, in light of the fact that this is unpaid, you can and arguably should have the any paid vacation, paid sick leave, any other types of paid leaves run concurrently with that 6-week period or the 10-day period, depending on which the scenario is, so that the individual can take advantage of the paid leave as well as this job-protected unpaid leave. And is not surprising, as with most leave acts, there is an anti-retaliation provision in there, which specifies that we cannot retaliate against any employee for taking any leave as allowed under this soon-to-be enacted law. Okay, so we are now on to our second secret word. Today's second secret word is car. Please select the correct secret word below, and I will give you all some time to do so. Couple more seconds. Click that car. Okay, now with that, I'm going to turn it back over to Zoe to discuss the recent changes to the Chicago Human Rights Ordinance.
Thanks, Susan. So we made it to our final topic of the day, and it must be the season for new labor and employment laws, as Susan mentioned at the beginning of this presentation, because the City of Chicago also recently amended the Chicago Human Rights Ordinance, and these changes are bound to impact employers who have employees in the City of Chicago in one way or another. In this last section of our presentation, I'm going to discuss some key aspects of the new amendments to the Chicago Human Rights Ordinance. So the City Commission on Human Relations recently amended the city's sexual harassment laws to make them stronger and uphold zero tolerance of violence and harassment in the workplace. Changes to the city's sexual harassment laws include: 1, enhanced definition of the term sexual harassment; 2, written policy and written notice requirements; 3, added safety measures for employees; 4, increased statute of limitations for employees; 5, new training requirements; and finally, increased penalties. And I'll cover each of these changes, starting with the city's enhanced definition of sexual harassment. And just to confirm, the Chicago Human Rights Ordinance defines employee to mean an individual who is engaged to work within the geographical boundaries of the City of Chicago for or under the direction and control of another for monetary or other valuable consideration. So an employee is an individual who is engaged to work within the geographical boundaries of the city. An employer means any individual, partnership, association, corporation, LLC, etc., or any agent of such entity or person, and must be subject to one or more of the license requirements in Title IV of the Chicago Human Rights Ordinance, or must maintain a business facility within the geographic boundaries of the city. The City of Chicago and its sister agencies qualify as employers for purposes of the ordinance. The first key change is to the definition of sexual harassment under the ordinance. So effective June 4th, the new definition of sexual harassment under the ordinance now explicitly includes quote-unquote sexual misconduct. The law provides that sexual misconduct means any behavior of a sexual nature which also involves coercion, abuse of authority, or misuse of an individual's employment position. So there are also new written policy and notice requirements for employers with employees in the City of Chicago. So as of July 1st, just a few days ago, all employers in the City of Chicago must have a written policy on sexual harassment. The policy must at least include 1, a statement that sexual harassment is illegal in Chicago, 2, the definition of sexual harassment and notice as noted on the previous slide, 3, a requirement that all employees participate in sexual harassment prevention training on an annual basis, 4, a requirement that employees shall participate in at least 1 hour of sexual harassment prevention training per year, with supervisors and managers completing 2 hours of prevention training each year, and a requirement that employees must participate in 1 hour of bystander training each year. The written policy must also include examples of prohibited conduct, details on how to report allegations of sexual harassment, and a statement that retaliation for reporting sexual harassment is illegal. The written policy must be available in the employee's primary language within the first calendar week of starting employment. Additionally, employers will be required to display a poster advising of the prohibition on sexual harassment where employees can see it. The City of Chicago Sexual Harassment Model Policy for Employers is available on the city's website, as is the sexual harassment poster for businesses. So you can find those on the City of Chicago Sexual Harassment Prevention page on their website. Another update to the Human Rights Ordinance is an added safety measure for employees. This includes an extended time period, 30 days instead of 10 days, for a complainant to provide a respondent, which in many cases is the employee preventing the employer, with a notice after filing a complaint under the Human Rights Ordinance. Per the city, this is intended to help mitigate any retaliation that could occur, such as a denial of a reasonable accommodation request under the Illinois Victims Economic and Security Act. So again, employees now have an extended time period, 30 days instead of 10 days, to provide the employer with a notice after filing a complaint under the Human Rights Ordinance. Another update to the ordinance is an increased statute of limitations period. This one's pretty straightforward. Employees now have 365 days instead of 300 days to report discrimination, including sexual harassment under the ordinance. Another component to the updated Human Rights Ordinance is mandatory trainings, as I mentioned above. So as of July 1st, again, just a few days ago, all employers in the City of Chicago are required to have employees complete 1 hour of sexual harassment prevention training and 1 hour of bystander intervention training each year. And again, supervisors and managers will be required to complete an extra hour of sexual harassment prevention training. The state training template, which provides 1 hour of training, would be sufficient for the sexual harassment prevention training for employees. And training modules for the additional hour of training and for bystander training were actually recently made available for employers on the City of Chicago's website. So in the same place where you can locate the sexual harassment prevention poster and the model policy, you can also find these training modules. So that would be on the City of Chicago's website under the sexual harassment prevention part of the webpage. Finally, the updates to the City of Chicago Ordinance include increased penalties for noncompliance. Anyone who violates the Human Rights Ordinance, including employers, are now subject to an increased penalty up to $5,000 to $10,000 per violation. So effective June 4th, 2022, just to summarize, the Human Rights Ordinance was amended to expand the definition of sexual harassment to include sexual misconduct. In addition, as of June 4th, the time period for a complainant to provide a respondent with notice after filing a complaint under the Human Rights Ordinance has been expanded from 10 days to 30 days. An individual who files a complaint under the Human Rights Ordinance now has 365 days instead of 300 days to report discrimination, including sexual harassment. And anyone who violates the Human Rights Ordinance, including employers, are now subject to an increased penalty from the previous $500 to $1,000 per violation to now $5,000 to $10,000 per violation. And finally, to summarize the items that became effective as of July 1st, all employers in the city will be required to have a policy on sexual harassment. Employees who work for an employer in the city will be required to complete 1 hour of sexual harassment prevention training and 1 hour of bystander intervention training each year. Again, supervisors and managers will be required to complete an extra hour of sexual harassment prevention training. Finally, employers must display a poster for sexual harassment prevention in a visible area of the workplace.
Thank you,
Now
Zoe. Thank you. I would just add that this is a good time to be, re-examining your employee handbooks because while on its face, some of the changes to the definition of sexual harassment might not look particularly new. Number one, I think it's important that we ensure that we have a robust definition of sexual harassment, but number two, they did come out and specifically call out the definition of sexual misconduct, which is not always included in an employee handbook. It's typical that we use the first two concepts of unwelcome sexual advances and requests for sexual favors, and then throw in the concept of sexual misconduct embedded in that. But here we have a directive by the City of Chicago that defines sexual misconduct. So I would recommend we all look at our employee handbooks to make sure that definition is in there. The other piece is that as any of you who have looked at the City of Chicago's template training, it requires that we tell the employees exactly where they can report any of their issues and give contact information for the Illinois Department of Human Rights, all of their various offices, contact information for the EEOC. It really does kind of spell out exactly how an employee will be reporting these kind of issues. So I have been recommending to employers who have individuals in Chicago to include that information in their employee handbooks because I think that ultimately that's what the city is going to be requiring as well. Most employers don't have that level of detail in their employee handbook, so I think it makes sense to go back and make that edit. And then at that same time, we can take a look at the Bereavement Act and see if that would be applicable and if the employee handbook needs to update that language as well. I should note, just since we are talking about the non-competes and the non-solicit issues, those should not be in an employee handbook. Those really need to be a standalone document that is signed by the employee because if we just want to rely upon the employee handbook, that's usually perceived by a court as more of a set of policies, as a piece of enforceable contract between the employee and the employer. So if that's the only place where you have the non-compete or the non-solicit, we need that to be a standalone agreement. I also recommend that confidentiality obligations are a standalone agreement as well. I see one question in the Q&A that asks, does sexual harassment have to occur during work hours at the place of work, or can it be outside of work? It's a great question and one that we ultimately receive from clients. I think it's incredibly important that we think of the concept of the workplace as very broad. We really never take our employee-employer hats off. So if two coworkers, whether it's a supervisor and a subordinate or just two equals, are in a hotel lobby bar because they are traveling for business, or if individuals go back to a bar after work for happy hour, or if we're having a holiday party, whatever the scenario is, if the coworkers are there together, I think we should assume that that could be deemed to have been workplace sexual harassment. It will not be a sufficient defense for us to simply say we are not liable for the conduct because it wasn't in the four corners of our office. The courts are going to take a much broader expanse on the definition of a workplace when assessing whether or not sexual harassment can be established under whether it's Illinois state law or federal law. And with that, we have reached our 1 o'clock. I know that there's questions that are still in the inbox, so we will be following up with each of you via email and providing you that the answers to those questions. In the meantime, I want to thank you all very much for attending and wish you a great rest of the week.